At the first meeting with a client, it's important to establish whether or not the marriage has broken down irretrievably, because that is the only ground for divorce. So we do spend some time talking to our clients about whether or not they consider that there is any possibility of a reconciliation, and we can refer them to local services such as Relate. If a client is adamant that the marriage has broken down, we then discuss with them the 5 facts which they need to establish to obtain a divorce. The 5 facts are adultery, unreasonable behaviour, 2 years separation with consent, desertion, and 5 years separation. The most common ground for obtaining a divorce is unreasonable behaviour. The reason for that is because it is subjective, so it's purely what the petitioner believes is unreasonable behaviour. It's very unlikely that the respondent would defend a divorce petition on unreasonable behaviour because of the costs involved, and the only fact that the court have to establish is that the marriage is over. Adultery is more difficult because if the respondent will not admit his adultery, then the petitioner has to provide evidence of the adultery. Once I've discussed with the client the particulars of divorce, a divorce petition will then be drafted for the client's approval. It is usual for us to write to the respondent to see whether or not they wish to have sight of the petition prior to the petition being issued, and also to discuss with them the issue of costs. The petition is then filed with the court. It is then served by the court on the respondent, and the respondent has 14 days in which to return a form to the court completed, called an acknowledgement of service form. If the respondent fails to comply with completing the form, then if the petition is based on unreasonable behaviour, we would normally arrange for a process server or a court bailiff to personally serve the respondent. This will then enable us to apply for the next stage of the divorce, called the decree nisi, because all the court need to know is that the respondent has had sight of the petition and has failed to cooperate, and the court will be satisfied that the petitioner can apply for a decree nisi. The decree nisi application is a straightforward application. It's signed by the petitioner or the petitioner's solicitors, and the petitioner signs a statement which is in a standard form and is filed with the court. The district judge at the local court will then look at the petition, look at the statement filed, and needs to be satisfied that the petitioner has satisfied one of the 5 facts for obtaining a divorce. The case will then be placed in a list, and a certificate of entitlement will be issued and a decree nisi date pronounced. Neither the petitioner nor the respondent need to attend court unless there is a dispute over the issue of costs. The decree nisi will be read out in court with a list of other names and the decree nisi date pronounced, and then the petitioner then has to wait 6 weeks and 1 day before applying for the absolute, which is the certificate that dissolves the marriage. The decree absolute is normally postponed if there are financial matters to be resolved between the parties, because the petition may lose some rights if, say for instance, the property is not in joint names, or there is a pension that the wife could lose some benefits from, or the husband, if a decree absolute was pronounced and then subsequently their spouse was deceased. As far as the costs of divorce are concerned, we, Family Law Group, do offer a fixed fee service. We offer very competitive rates. There is a court fee that is payable to the court, which is £410 at the current time. Now, if the petitioner is on a low income or on state benefits, they can apply for fee remission. What that means is, if they provide evidence of their income, such as bank statements, pay slips, the court will assess whether or not they have to pay anything towards the court fee or whether they have to pay a proportion of the court fee. This is always an option that we give to clients when we see them, because we are conscious that they want to save costs, and if they can, we will assist them in doing that. We offer a number of fixed fee packages for our various sorts of work that we do. In particular, a client may instruct us to just deal with their divorce. They may ask us to deal with their financial cases as well. So we can offer fixed fees for each part of the process. Typically, a divorce will take between 4 to 6 months if it is intended that the decree absolute is applied for as soon as possible.